First, I thought you guys had bags of chips on your table. I thought, wow, we're getting comfortable around here, aren't we? Okay. Yeah, looks like Lay's. All right, state versus plain. Mr. Dickey, it's my understanding you will argue this case first, and then we'll have either, looks like Mr. Walker this time, and then Mr. Sloven. So, Mr. Dickey, you may begin.
Thank you, Madam Chief Justice, and may it please the court. I'm Gary Dickey, appearing on behalf of Mr. Plain a second time, asking this court to reverse his conviction and remand for a new trial on the basis that the jury panel from Black Hawk County systematically underrepresented African Americans. With respect to the second prong of the Duren analysis, the state concedes that the district court committed two fundamental errors in its analysis. The first is that the district court took the two data sets prepared using geocoding analysis from Paula Hannaford Agor and averaged the two. That was a result that neither party asked for. It's not explained in the record and really is counterintuitive, as the expert testimony was that the Model 2 was the more accurate data set. It would seem to make sense you would use that only. In any event, even under the averaged data sets, the bigger flaw was that the district court's math was just incorrect. Even assuming the data sets that the district court used, the correct math shows that the standard deviations were in excess of 2%, particularly as the potential jurors made their way to the actual jury panel. So with respect to the second prong of Duren, there seems to be no argument on this record that the district court erred. As to the third prong in terms of systematic exclusion, the district court's specific finding was that Mr. Plain was unable to pinpoint the precise place in the jury selection process for which there was the cause of the underrepresentation. We submit that that's an error both legally and factually. As a matter of law, the district court applied a too rigorous of a standard. As this court articulated in Lilly, a defendant need only identify a plausible explanation of how the operation of the jury system resulted in the exclusion. That language sounds an awful lot like the language that the United States Supreme Court used in Durham, which was to require a prima facie showing.
What is that standard? I think in your brief you said that it is but for. Is that it?
But I think if we are to use the Durham standard, which remember is just a burden of production, and it's a burden shifting framework, there needs to be some prima facie case. So the defendant doesn't have the ultimate burden of proving beyond a reasonable doubt or clear and convincing evidence, or even more likely than not, just some evidence or a plausible explanation under Lilly as to what could be causing the underrepresentation.
What expert do you rely on for kind of identifying that?
In this case, it was the testimony of Paula Hannaford Agor.
What testimony was that specifically?
It was her data analysis that there is a reduction in the number of African Americans at every stage as we work through the jury selection process to ultimately placing them on the panel. And then she identified shortcomings in the Black Hawk jury selection system that are known have been supported by research to cause these types of underrepresentations. So for example,
Before you get there, were they run-of-the-mill issues or were they different? Because I think that potentially matters, right? Depending on where we come down, whether this is a Sixth Amendment issue or Article 1, Section 10.
That's where we could use some guidance as to what run-of-the-mill matters are. I mean, when a jury selection system is producing outcomes that underrepresent minorities, to the degree to which the standard deviation statistics bear out over time, and the court does nothing to address that, it's hard to say that that's just run-of-the-mill. And so if you compare the actual practice in Durham to what happened here, so in Durham the practice was women were given a second opportunity to get an exemption, and in Jackson County, Missouri, there was no accountability for women who failed to show up. I mean, that's that's what we have here is we see that African Americans are shrinking in the representation as the jury selection process goes forward. And the expert testimony is that very well could be attributed.
Curran is different because the jury manager was bending the rules only for women, whereas there's no allegation that in Waterloo, the standards are different or more lax as far as African Americans or whites getting people to the courthouse, right?
We submit that's a distinction without a difference. So if under the Sixth Amendment, we were required to show conscious or intentional discrimination, that argument would have merit. That's not a requirement. And as this court held under Lilly, when you have a system that over time, it has producing results that result in underrepresentation, then that is evidence of systematic exclusion.
Matter. Let's take one of the issues, which is the different response rates among the different races. What obligation do the courts have, in your view, then, to take action, or what responsibility does the court have for those individual choices that are made?
You raised the word choice, and that's really, that's kind of a misnomer here. There is no choice. That we have a closed system here where we have a known population of people from which to select, and there is no choice to disregard the jury summons, just as there is no choice to appear and volunteer for jury summons. So when my friend on the other side says that, you know, the randomness can be attributed to choices, that's a
policy. Are you saying the Constitution requires that as a court system, we disproportionately cite African Americans for contempt of court, for failing to respond to a jury summons, potentially incarcerate them and fine them, to create an enforcement mechanism that has 100% compliance in responding to jury summons? So what is the solution to people not responding other than kind of absolute 100% enforcement of the summons?
So a good start would be 100% enforcement. Well, we're not proposing selective enforcement. I mean, what the record shows from Ms. Traylor's testimony is that when they started to enact some of the jury practices that were attributed by our expert as to causing some of this, you know, instead of having to call in 100 jurors for a panel to get response rates, they only had to call in 85. And the numbers seem to suggest that there is some improvement when you have actual enforcement. So we're not suggesting you have to selectively enforce or selectively prosecute contempt actions, just if you set up a system in which non-compliance is not tolerated.
If one race is not responding at a disproportionately high rate, and we have 100% enforcement, as a branch, we will be disproportionately pursuing contempt actions more against African Americans. I mean, that's how the math works, right?
Sure, but that's not a Sixth Amendment problem. I mean, perhaps it's a 14th Amendment.
Very practical solution. It's very easy to identify kind of mechanisms where this is occurring, but what is a real practical solution for us as a court system where we want to keep advancing this?
Is serious about looking at a solution in this situation. If you have a county like Black Hawk where data shows over time that African Americans are 20% less likely to respond, then what you do is you model for that non-response rate. And so you run 1 million scenarios until you have a response rate that's essentially 120% to account for the known under-response by African Americans. So that would achieve an outcome that's consistent with the Sixth Amendment requirement of fair representation.
And what you meant by there is no choice. I mean, once the notices are out, whether or not somebody shows up, maybe technically it's a summons and everybody knows legally you're supposed to come. But the truth of the matter is there's not a great turnout. So how is that not a choice?
It's a choice in the sense that if you allow it to not be enforced, then people aren't going to show up.
other end, whether or not a person comes, I mean, they're the ones, there is some choosing, and it's not just at the African-American race. I know that from being a trial court judge. It's hard to get people to take it seriously and to show up across the board. So you meant choice on the judiciary's behalf?
So, as I understand the state's argument, they're attributing some of the play in the variability to individual choices of African Americans and individuals in lower socioeconomic. And choice only comes into it if the court system allows them to choose. So when you have a period of non-enforcement over years, non-enforcement at all, of course, people are going to choose not to show up because there's no consequences. If you had a perfect system, you would send the sheriff out to find them and pull them the same day.
It happened. And in a community where people pay attention, it works for a while. But it isn't because of the notices that were sent out. That person was notified. It's just the enforcement that you're talking about.
Naive to suggest we can have a perfect system of pulling everybody in that same day. But what the expert testimony is in the record from Paula Hannaford Agor is that improving enforcement can have a dramatic increase as much as 20 to 45% on the response rates.
The fact that, and see if you agree with me, that if we do that enforcement, I don't know about you, but when I used to try trials, if I knew somebody just got pulled in by their ear by the sheriff, I'm probably not going to want them on my jury. They're not happy to be there either. So unintended consequences there as well, correct? Couldn't that blow up in our faces?
From a criminal defense perspective, representing an African American, if the court is pulling in another African American who doesn't want to be there voluntarily, strategically that might be to the defendant's benefit. I understand from a jury management perspective that's less than ideal for the judge. The state may take a different perspective, but as the social science statistics bear out, as identified by this court in Plain, when minority defendants have a representative, a jury that is more representative of minorities in the community, the outcomes improve.
Enforcement by having the sheriff go out, what other ideas do you have for what can we do short of the list that we have, and we have been trying to expand our lists and hitting kind of a barrier there. What else?
So the only other one that comes to mind is the one that I suggested to Justice McDonald, is that we can run simulations until we have a jury summons list that takes into account known underrepresented response rates for minorities. So with respect, again, getting back to prong 3, with respect to the evidence that's in the record, the math from the standard deviation, although not sufficient, it's not been recognized by any court to be sufficient in and of itself to satisfy systemic underrepresentation. It is evidence of systematic underrepresentation. What standard deviation measures is the amount of randomness. And so once you get to the point where you're so far out of randomness, the only other explanation is something within that closed system of jury selection. The second piece of evidence was the testimony from Paula Hannaford Agor with respect to out-of-date summons list, which contribute to a lower response rate by as much as 10 to 15%, as well as what we've already talked about, the explanation from her that failure to hold potential jurors accountable contributes to lower appearance rates. And then
She look at the practices of this court in 2015 when she provided her testimony on those issues? Or was she speaking sort of more generically?
So her statistical analysis with respect to that I just cited is what is in the literature, as opposed to looking at the specific practices of this court over time.
She didn't look specifically at what this court was doing in 2015, did she? I thought that she testified that she had not. Am I remembering that incorrectly?
Specific opinion was that this practice caused this. What she identified is issues in the jury management practices, which have been studied over time in large data sets, and when they've changed, the improvement. And then that's where you set her opinions next to the facts of this case, and that's a plausible explanation under Lilly, and it's sufficient to establish a prima facie case under Duren.
Just so I'm clear, she didn't say Black Hawk County did X. Had Black Hawk County done Y, result would have been different. That, and therefore, that is the cause.
Do that, you know, if that's what the court wants going forward, I don't think that's realistic on the day of trial for me to go get an expert to then kind of project in the future what the outcome would be if we change a practice that we identify as being deficient. We can look at other jurisdictions that have made changes in their practices and draw inferences, but if I'm on the day of trial arguing that there is a failure to enforce summonses, I can't then get an expert to testify what that will mean in the future if we change it when the change hasn't been made.
Can I ask one question? To Justice McDonald's question earlier about res judicata, if we were to find at prong 3 that you did satisfy your burden, is that res judicata going forward in other cases?
So what I could tell you is the analysis I think applies is if there's an identity of interest and there's an identity of issues and the record is the same, res judicata would apply. I think that means we could use it for offensive collateral estoppel against the state. That analysis may not hold up given individual differences between criminal defendants. And then, of course, as the data sets change over time, certainly that's an issue that would be raised and litigated. So I'm open to that. Yes. Thank you.
Mr. Walker.
Madam Chief Justice and members of the court, may it please the court, thank you very much for the opportunity for the NAACP to appear before you today in addition to submitting their brief. I'd like to address myself in the 5 minutes available to me to 3 points. One would be to emphasize the importance of this state versus plain case to the NAACP and our members, but I think everybody across the state. We viewed it as a landmark, and absolutely it was an impetus to reforms that are ongoing, that have occurred. The amendments to 607A of the Iowa Code in 2016 and 17, the jury management policy, what has flown from the Lilly trilogy in 2019 to most recently the Office of State Court Administration's policy on jury data collection and reporting, in which it's going to be gathering on an ongoing basis with respect to each county, data regarding race and gender for the pool and for the panels. It's the panels that are particularly important. I would like to address in this time the prong 3 and in 2 ways. One, I want to emphasize certain facts. Justice McDermott asked about Paula Hanford-Ager's charge. She said twice, I was asked to look at the potential contributing factors were to underrepresentation in the jury pool in Black Hawk County during the year that the Plain case was tried. Now, she didn't look at the specific text of the reminder card or letter for failure to respond to a questionnaire. She didn't look at the specific letter on a failure to appear, but she was looking where the responses was. 3 points. One, on undeliverables. She said that the undeliverables in zip code 50703 were not statistically significantly higher than the rest of Black Hawk County, but failures to respond were, and that's what she identified as the contributing factor. And here's what I want you to point out, as she made clear in her record, that as much as half of failures to respond are actually undeliverables. And studies have shown that. She mentioned a St. Louis study, she mentioned an American Judicature Society. So we can't take lightly that undeliverables are unimportant. The state today requires use of the National Change of Address system for every pool that is formed. And jury managers could do that too, but with the state doing that, it would not be necessary. The failure of the state to utilize the National change of address system is something that the NAACP points to as a likely contributing factor, because as my counsel for the appellant said, use of the NCOA reduces by 10 to 15%.
And so I'm reluctant to interrupt, but I just want to make sure I understand it, Mr. Walker. So what you're saying is what Black Hawk County records as they don't, as far as they know, it was delivered, but that doesn't mean it actually got to that particular human being because that human being may have moved.
Just as we do with
Didn't send it back.
mail, that doesn't apply to us. The second thing I want to emphasize, in addition to the 10 to 15% reduction in undeliverables at NCOA, I think would have utilized was the reminder letter that Black Hawk County jury manager sent out was pretty insipid. You know, Paula Hannaford-Ager said, what we do know, and again, this is from the American Judicature Society, was the single biggest predictor of whether or not a person failed to respond or failed to appear for jury service was their expectation about what would happen if they didn't. People who believe that something bad will happen, they'll get arrested, they'll get fined, they'll get called into court and yelled at by someone, significantly more likely to appear and to respond to a jury summons than people who believe otherwise. The third point
The run-of-the-mill issue, what are we supposed to do about that if we find that this case does not fall under Article 1, Section 10? Aren't all of these issues run-of-the-mill issues? I mean, what are we supposed to do with that?
collective challenge to all of us involved in the judicial branch and judicial system. It is something on which we've been working with the state court administrators since September of 2017, looking at the jury questionnaire, mandating answering of the race question, for example, explaining why that information is needed, public education within the NAACP. I reject the notion that it's black people who don't respond to questionnaires and appear. When Paula Hannaford-Ager says that that data is adjusted for socioeconomic level, it's clear that low-income people alike, black and white, fail to respond. And it, as Gary Dickey said, it's a rational choice, given the pay level of jury, given the forfeiture of what you would be earning, given the fact that employers don't have to pay that, and given the fact in Black Hawk County that it took at least 3 times to failure to appear when a jury was actually impaneled before the possibility of a contempt hearing occurred. Only 10 to 20. In under the current rule, that's increased by 5 to 10 times. My third point was going to be that it is not strange to impose on the state, under the 6th Amendment and under Article 1, Section 10, an affirmative obligation, whether it's a speedy trial, whether it's appointment of counsel, or here the utilization of efficient jury management practices that, for my part and for the NAACP, are pejoratively cast as run-of-the-mill jury management practices. These practices are good practices for operating a judicial system and a criminal justice system that comports with the 6th Amendment and the Iowa Constitution. They shouldn't be denigrated. No, it came from the Berges case. No. No apology needed. It was the Berges case. I thank you for your time, and it was a privilege to appear before you.
Mr. Sloven.
Thank you, Madam Chief Justice, and may it please the court, counsel. So I want to start with Justice McDermott, your question on what is the standard? What does the defendant need to prove on prong 3? I mean, especially, I now recognize the danger of the res judicata question, that if it's proven once, it'll be weaponized offensively against the state in all future cases. I think that on its own should clue us into that it has to be more than a plausible theory, has to be actual proof, has to be more than notice pleading. Lilly said the defendant has to prove causation, alleging a plausible theory is a starting point, but you actually have to prove your theory that a feature of the jury selection system caused underrepresentation through systematic exclusion. For most constitutional
Shifting notion. And let me open up the larger question. There's some pragmatic problems in terms of timing and resources. I mean, this comes up right before trial ordinarily, and necessarily it does because we don't have the, kind of jury pool information. There's no way that doesn't come up on the eve of trial. So on the eve of trial, we're expecting a proper record to be made and statistical analysis to be presented that proves kind of precisely what's going on. A, is that practical for a defendant to do that? And B, what about some kind of burden shifting approach where as long as like under Durham, a reasonable argument is made, maybe the state ought to bear the burden more on some of these issues. Anyway, you understand where I'm coming from. It's a question of resources and timing, and why don't you address it, however?
in some contexts where you can infer from opportunity in the system to invidiously discriminate and underrepresentation over time that some invidious discrimination. Now, I'm not trying to cross the streams between these two claims, but right, yeah, I know that's not an element of this claim. It's just the way in which it was used in Castaneda. Anyway, but I think that there is a certain level where you could show a certain exorbitant level of underrepresentation over time, where you would start to ask, kind of like Duren, where it's obvious how it's happening, and then it shifts to the state.
The state has the resources and it has information at its fingertips a lot. At least it's more accessible to the state, it seems to me, than to defense counsel on the eve of trial.
Moving target, it's the same juror selection and jury management system that's being used in the county for all trials, criminal and civil. The bar, attorneys who practice in that community can develop a familiarity with it and be ready to raise challenges. And it's not as though the system itself is revealed on the eve of trial. In fact, the only thing that is different on the eve of trial is the actual jury pool and panel selected. The part that can produce the injury to the actual defendant, which, I'm still going to pushing for our approach to prong two, that you should, the defendant needs to show that there was underrepresentation in their jury pool or jury panel, as long as zero would establish it, as long as there is a expectation of a level of fair and reasonable representation that's above zero, it's either met or not met.
3, what's an example of what a defendant could show on the day of trial that would satisfy their burden?
So on the legal standard, for most constitutional claims, most Sixth Amendment claims, preponderance of the evidence. Now, for a factual showing, I think that once you get there and you make a showing on prong two, it is, then you should have an inquiry, and you might need to take a little extra time to do that, because if you don't, if you say, oh, the defendant has carried prong two on this jury pool or jury panel, or this one plus the last one if this one's not big enough, and if we proceed, then we can violate their Sixth Amendment right. So we need to make sure that there's no systematic exclusion happening. So I agree that it's gonna take some time to make that evidentiary record. But the good news is the officials who need to be called, who are involved in it, are known. Experts in this area are published, and their names are special, if not before this litigation, then now they are. And the defense bar can be ready to make that kind of a claim when, or at least ready to schedule it.
Takes.
It can take a while. But the point is that, so first, by adopting a practical, pragmatic, and readily implementable standard for prong two, you avoid that inquiry in cases where you don't need to make it. And then when you do need to, I think I agree that it's an important right that should be vindicated, and it may be necessary to delay trial. In Veal, this court said it was good cause for delay on speedy trial in order to conduct that inquiry. And if there is a merit, now res judicata can help here. If the claim that's being alleged is you're not doing good enough enforcement, and this court has already said as a matter of law that can't qualify, well then you know that that doesn't state a claim under systematic exclusion. Now,
on causation. As you know, there's huge literature on what causation is. I mean, there's but for, there's more likely than not, there's likely to be a factor. I mean, I heard likely to be a factor, and I kind of circle that in my own mind as kind of a lower showing of causation. What's your view of the choices that are available on causation, and what's the correct one?
I think it has to be but for causation. I don't see any other way to read these cases that the underrepresentation in the veneer is caused by systematic exclusion. It has to be, if you didn't do the thing that was systematic exclusion, we wouldn't have this kind of underrepresentation. And I think that just logically flows. I want to talk about this specific case. Well, oh, actually, I have more framework to do. If
you have to show that a factor, let's suppose there is a systemic exclusion and it has some impact, but there's no testimony that the impact would be sufficient to get the jury system back and killed her. That would fail, I take it, even though it was a substantial contributing factor in your view.
Yeah, that some of the underrepresentation is caused by this thing that's systematic exclusion, but not all of it. That's a trickier claim. If the amount of underrepresentation caused by the thing that is systematic exclusion, if that is enough that the thing that the court system is doing is violating the Sixth Amendment, then yeah, that's enough. But if you're showing that here's a policy that is systematic exclusion, and it's, and there is a pattern of underrepresentation, but this policy is only responsible for 0.02% of people not showing up, you can't say that you've proven that systematic exclusion is causing constitutionally meaningful or substantial levels of underrepresentation. You could show systematic exclusion and also a pattern of underrepresentation just because humans are non-random.
I mean, apparently, you're really requiring expert testimony, because no way would non-expert testimony be able to say, well, here's a statistical analysis of prong 2, and here's the exclusion on prong 3, and, I've got to get to 12 or 13 or 15 or some kind of mathematical construct to bring it within the claim. So you'd have to have a statistical analysis, I guess.
Our goal should be that we don't need statistical experts, that the statistical analysis is something that lawyers and judges can do. I think that a lot of times you will need experts to testify about how, if there is an interaction between a jury policy and underrepresentation in a way that's causal. Now, a lot of people put in a lot of work to get rid of all policies or practices where the link is as obvious as it was in Duren. We've put in a lot of effort to make sure that our system is race neutral, race blind.
I had in mind when I wrote Lilly, and not Plain, I didn't, it was just a sec, but Lilly and the other cases was, you could easily get to a situation where on prong 2 you don't need a statistical expert. You just need lawyers that have some, and judges that have some basic understanding of statistics. But then it does seem to me at the prong 3 level, it is kind of like trying an employment discrimination claim, a disparate impact employment discrimination claim. And at that level, maybe you do most of the time need an expert. Isn't that right?
Said in Lilly is right. You almost always need an expert. Now, there's going to be, I'm not going to say there aren't going to be some cases where you can show what happened and it's apparent, the causation is apparent. But you need to show causation, and we're trying very hard to run a jury system that doesn't do systematic exclusion. We've sanded off all the obvious edges, and to prove causation, you need.
What I hope we would get to in Iowa is, because Mr. Dickey certainly raises a legitimate concern, and Justice Appel raises a legitimate concern, where we, through some test cases, we identify the issues, we litigate them, we find out if there is systematic exclusion or not, and we settle the issue, and we clean up the problems.
Publicity where there's always going to be, the system's functioning correctly when there's always going to be some publicity of trials and you always have to litigate it. This is a situation where we're making forward progress, improving the system, and at some level, at some point, we will get a system that works well enough that we won't be systematically excluding.
I think it's the state's position that it shouldn't be responsible, as you put it, for second-order consequences from facially neutral practices. I assume you're referring to kind of choice in responding to jury summons. I guess my question is why not? If the Constitution imposes an affirmative obligation on the state to have a fair cross-section, why doesn't it have an obligation to correct known deficiencies, even if those deficiencies are being caused by private choice?
The framework I'd apply to this is actually from the Hannaford-Agger article that is quoted in Lilly. Later in the article on page 794, it says, here are some limits for systematic negligence theories. Courts aren't required to take measures, corrective measures that are exorbitantly expensive or that do not have proven effectiveness or debatable effectiveness. That either justification is a reason why a court why not implementing a certain policy isn't a Sixth Amendment violation. And then 2 pages later, it actually talks, Hannaford-Agger actually talks about practical limits on the usefulness of extremely aggressive enforcement programs, which become increasingly time and labor intensive to administer. Now, I hear what you're saying. There's an affirmative obligation to create some sort of a jury selection, jury management system that not only isn't barring the door to certain people, but is taking reasonable efforts to get a representative fair cross-section and is built in order to do that. I think that the record here establishes that that's what was happening. Now, Hannaford-Agger did not specifically testify about an examination of Black Hawk County's practices, but what she did testify about is NCSC research showing that on your second round of mailings, the first reminder to somebody who doesn't respond, to the first failure to respond or the first failure to appear, sending out that second round, that first reminder, that increases your yield by 24 to 46%. Ms. Treloar testifies here that that's something that they were doing. That's in her testimony and in her deposition. If you look at Exhibit E of her deposition, which is filed, so it's E within Remand Exhibit 115, you can actually see the letter. And the letter says failure to appear or failure to appear for jury service, which is what you've done by not responding, can be punished punished for contempt. So if we're talking about the single most effective thing to spur people to appear, to make that choice, is an expectation of what may happen if they don't.
What about Mr. Dickey's suggestion? What would the state's position be on, let's say there's research done and an algorithm was developed which showed that if you sent 25% more jury summonses to zip code 50703, that would end up equalizing or getting closer to the actual percentages in the jury eligible population for people appearing for trial. What's the state's position on that?
More sense to me than what I heard was just send more generally. And I don't know how doing that would get you more from a particular group. But if you're talking about some sort of geographical stratified sampling, where you send more to cover for undeliverables or failure to respond in a certain zip code, that is a policy that could be implemented, but Hannaford-Agger's article goes on to say that those have mixed effectiveness in area. I know Georgia's had one for a long time, and there's been some efforts to try those kinds of systems in other places. They have mixed to limited effectiveness, and also they can be more expensive, requiring additional. There's actually in the answers submitted by ACS, the very last answer they give, I believe it's in Exhibit 130, is about they could develop that if the judicial branch asked for it, but it would require a lot of data and a lot of tweaking down to the individual zip code. Now, it also requires more of a lead time. Because what we have now, and Ms. Treloar testifies that 5 weeks before trial, she was sending out drawing the names, sending out the paper packets before 2018. And then 2 weeks before trial, if she hadn't heard anything back, she'd send out the failure to respond. So if you're doing another round to replace non-response with other people from the same zip code, not only do you need new software, you need more time in there, and you need a longer lead time, you need additional. So I'm not saying it's impossible. I don't think the state's burden is to show that this is impossible to do, but I think the defendant hasn't met the burden of showing that not doing this at the time was negligent, that any reasonable jury manager or reasonable state court administrator would have already known to implement a system that did this. Now, I think that it's worth talking about that this is an individual choice that people are making. We can incentivize and carrots and sticks all we want, but we still need people to get the questionnaire and choose to respond. And Madam Chief Justice, I agree with you. A reluctant juror is frequently an angry juror, frequently a bad juror. It's not to say we shouldn't try to get people to respond. I think we should. But I want to point out that in the reply brief, Plain cites to Bates, a case that says that the opt-out in Bergui was something that the Sixth Circuit found analogous to Duren. Now, I don't agree. The Duren opt-out was specifically made available to women, and there isn't actually an express opt-out. People are told they'll be punished for contempt. But to the degree you think there is, it's for everybody. But then Bates goes on from that to say, what's really happening in Bates is there's a certain zip code where the non-response rate is double what it is for other zip codes. That's the zip code that's disproportionately African American. But those failures to respond are individual choices that are being made by recipients. They get the summons, goes on the kitchen table, they choose what to do with it. And that individual choice, I mean, no representative of the judicial branch is in the room with them when they make that choice. We can't control that.
Question, if prong 2 has been satisfied, if the defendant has been successful in showing prong 2 is a problem, and then we move to prong 3, and if prong 3 requires an expert, I'm trying to play this out in my head. It's kind of like the rose from Beauty and the Beast. Once you start a trial and the process, those little petals start falling off. Are we going to put juries on ice? How long, what would that look like? Help me understand what that would look like, because you'd have to be talking about either the pool or the panel you've got. And how do we keep them? I mean, they're moving targets. They say, I can serve on this jury duty, but I've got a trip to Spain certain time, and we're going to lose people too, or health. How does that work?
So one thing that can be done is a district court can summon additional pools or panels, either to try to alleviate apparent underrepresentation by getting a more representative sample, or to try to get more people who are able to have kind of jury service on standby while that inquiry proceeds. I think that, I agree with the writing that's been done about defense counsel needs to have an understanding of how this system works so that if they see a pool for which proof of prong 2 can be made, that they are ready to go with a theory of systematic exclusion, that they, maybe they need to contact an expert, but they're not at the basic research stage, which if people think that there is a glaring systemic problem with our jury selection system, I mean, that's not an opinion, a conclusion that you come to, start on Monday, get there on Tuesday. But
state of the law of what other courts are doing with prong 3 when the state is using voting registration and driver's license or state ID lists. Have those challenges been successful or not?
Challenge on which a court has, I think there's the Green case, but that was reversed on appeal. I'm not aware of any other case where that was held to be exclusion. I'm not aware of any case where jurors' individual choices in how to respond when the summons are delivered was held to be systematic exclusion. I don't think any other court has adopted systematic negligence, to my knowledge.
There's a filament out there in the law, Barber versus Ponte. Are you familiar with that one? It's a First Circuit, yeah, 89 actually, I think maybe, but whatever. Yeah, it talks about a large discrepancy in jury pool over time. That's sufficient to show systemic problems. I mean, so I think it's fair to say that in a lot of cases, the mere presence of some problem on prong 2 isn't enough. But if you have a pervasive problem on prong 2 over a long period of time, there's at least dicta out there saying that that's going to be sufficient to show systemic exclusion.
I think, the weight of authority is definitely in favor of, you need to show that something that the jury selection system did was causing exclusion, not just people were making, I see my time's expired, if I can just have a brief moment to sum up. Thank you. And the weight of authority is in line with that, and also that the weight of authority, the fact that it exists, the fact that this underrepresentation is something that a lot of courts across the country are observing, I think speaks to the fact that there is no silver bullet solution. To find that systematic negligence is happening, you would have to find that there's a something that a reasonable jury manager or state court administrator would do to fix it, that would fix it, and that they're unreasonable for not doing it. And I don't think that on this record or in the broader literature that you can find there's something that wasn't being done in Black Hawk County here that would have alleviated the problem. Thank you.
May it please the court, I want to address a couple of the issues that were brought up in the state's argument. I think it's important that this court recognize that there is a difference between a causation standard and the standard of proof. And I think that's where the district court's ruling went astray. So even if we use a but for, and I'm not suggesting that we need to show but for, but even with that higher of a standard, the standard of proof, at least as articulated by Lilly, is a reasonable, plausible explanation. The standard of proof that is articulated under Durham is simply a prima facie. So while that is something that is more than notice pleading, it's not something in which a defendant has the ultimate burden of persuasion in order to satisfy the court. I think that's what the district court lost sight of. On this record, we had the expert testimony of Paula Hannaford Agor, which was unimpeached. There was no competing expert, and the district court simply disregarded her expert opinions and the testimony in the record based on arguments that were provided by the state. The other aspect is in terms of finding a framework that is workable. I think the court should not lose sight of the fact that in some counties, particularly Polk County, you may not get a jury panel until the afternoon. You may show up for trial and wait for some other courtrooms to select their juries, and you get the leftovers. We're never provided in Polk County the jury pool information. So
It's getting at. I think that's kind of common.
And so that's from a practitioner's perspective, that's the criticism with the standard deviation, is we also don't have in real time access to historical data by which to compare. So in terms of, as we continue to improve our jury selection process, I think, Justice Apple, you identified it in one of your concurring opinions, trying to remain flexible on the second prong of Durham is a more practical approach to the realities of criminal defense practitioners. And certainly by changing the burden of proof or shifting the burden of proof after an initial prima facie showing by a defendant would be consistent with other areas of constitutional law. For example, Fourth Amendment allegations. The state has the ultimate burden. When we show a constitutional deprivation, on appeal, then the burden of prejudice shifts to the state to show it was not prejudicial beyond a reasonable doubt. And then just as a factual matter, I think in the record there is the exhibit from the jury manager dated July 16, 2015, to which I think Mr. Sloven was referring, is actually a letter that threatens contempt after a failure to appear. So not necessarily just a failure to respond to the initial summons, but actually not showing up is what the language of the exhibit shows. So if there are no other questions, I would yield the balance of my time to my colleague, Mr. Walker.
Got just shy of 2 minutes.
Thank you very much, Madam Chief Justice. Some points. One, sometimes there's a duty to act. We know that as parents. We know that's true of corporate directors. The NAACP believes that's true of the judicial branch. We agree with Paula Hannaford-Ager, quoted by Mr. Sloven, that where it's not burdensome and not unduly expensive for the judicial branch, there's an affirmative obligation under the Constitution, federal and state, to act. Two, the page on which, of the record to which Mr. Sloven was referring is page 45, lines 1 through 9. The question, so in places where they have increased the frequency of the prosecution for failure to appear, and then in places where they do more to follow up, there has been a reduction in those failures to appear? Absolutely, Paula Hannaford-Ager said. Yes, in fact, What we've found is that courts that have consistent and timely follow-up on non-response and failure to appear rates typically have, those rates are 24 to 46% lower than courts that do nothing. A third point, I want to address Chief Justice Christensen and Mr. Sloven's concern about the angry juror, the bad juror. My experience at different points in my life, I've never been a judge, but I have had occasion to talk with people who have strayed or not done what they were supposed to have done. And in most of those instances, people are willing to admit, especially when we explain the importance of jury duty. I will tell you that to the NAACP membership, to our executive committee, to black people, the racial disparities in incarceration are a source of deep pain, and it's important to make people realize how critical their service on juries is. The data that Mr. Dickey just referred to, saying that access to historical data in real time is difficult, that is exactly what the Office of State Court Administration, in a memo I believe is available to you from then State Court Administrator Todd Nucio, about which we spoke recently with Acting State Court Administrator John Curt, is April 5th, 2021, in which they committed to gathering that data by county, and within Lee County, of course, would probably be by division, so that it would be available to counsel ahead of time. And finally, it's still green. I think that a voting list and non-operator ID and driver's license have generally been upheld. That doesn't mean that we don't recognize problems. We cherish the support of the judicial branch for the House bill that failed to advance. We will keep working on it because we know that the pool can include a more diverse as well as more current setting. But again, we want to emphasize our concern, as Mr. Dickey expressed, is with the panels. That's where Professor Anwar's comments say it was so important to have racial mix in order to eliminate the differential in conviction rates between all white and racially mixed jurors of African American defendants. Thank you very much. I'd be glad to answer questions if there were any.
Okay. The case of State versus Plain is hereby submitted. And if I didn't say it before, also the State versus Wilson is submitted without oral argument, and we are adjourned for the day. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.